you need to take the time. Second is, and I know this sounds old school, review it in hard copy. Our firm has been paperless since before it was cool. But there are certain things that we don't do only electronically. It is a statistical fact that the human brain catches more things in writing hard copy than digitally. In fact, there was, among many others, a study done in 2009 that used a type of MRI scan of the brain to observe how the brain processes sort of physical, tangible materials versus digital materials. They activate completely different parts of the brain. The studies also showed, as an example, that the act of scrolling down the screen or dragging the mouse, it demands more from our brain in the active memory, which blocks us from absorbing all of the other important details. This kind of study has been replicated many times over. So do it in hard copy. You'll be far better served by that than digital alone. Read every word, and I mean every word. And I know that can be, again, time-consuming process. Don't just look at the scope of work, the plans and specifications, and the price. You have to read the entire thing, even what is commonly referred to as legal boilerplate. Really, there's no such thing as legal boilerplate. What that term meant 100 years ago was that there was one standard way to write something in a particular kind of agreement, thus the boilerplate. If it's uniform and we know what it means and we see it's there, we don't have to study it too closely. There is no such thing as traditional legal boilerplate anymore. Things are highly customized in these contracts, and failure to read it in its entirety could really get you in trouble. Make sure that when you're actually reading it, when I say the entirety, I mean, don't just read the four corners of the document you have. Read everything that's incorporated by reference. So, for example, the American Institute of Architects, as I'm sure all or many of you know, has a robust series of contract document forms. There are pros and cons to each. And just because you read a A101 contract yesterday doesn't mean you're actually reading the same A101 form today. They're updated on cycles of 7 years. So even the year of the form could have drastic differences. Additionally, as an example, the A101 series, which is a common fixed price, incorporates the A201, which is the general conditions of the contract, but it's not attached, the A201. The A201, unlike the A101, does not have to be signed and never is. In fact, there's no signature location on the A201, but it adds roughly another 38 pages of terms and conditions to the contract. As a war story from probably 6 or 7 years ago, we were representing a contractor that was working on an FDOT project. And of course, the FDOT has its standard road, bridge, and other specifications, and then project-specific ones. Well, FDOT has buried in the, what I'll call the construction science, the technical portions of the standard specifications, certain contract and claim preservation provisions with extremely short time fuses. Some of them were as short as 7 days. And they're buried in the science sections of the contract, not where you would look. So you have to be very careful to read everything. Use a checklist, right? Whether it's receiving a copy of this slideshow today that talks about some clauses, or having another resource, whether it's legal counsel or otherwise, prepare a checklist for you. It helps you with issue spotting. But you have to be careful not to lean too heavily on the checklist, simply because, again, you'll miss the analytical pieces. But a checklist will help a great deal. Use implements, as I call it. Now, if you're doing it digitally as opposed to hard copy, then use the equivalent digitally. But so I'm not talking hard copy, right? Use colored pens, sticky notes, different colored highlighters to signify certain things. Because again, you're going to be moving back and forth between many pages of documents, and you need that kind of simplistic, attention-grabbing implement to help you through the process. Certainly, if you're doing markups through Adobe or other things, there are ways to have comparable tools, and it's really important. Again, these are some of the tools of the trade, whether digital or hard copy, that legal professionals are using. Would encourage you to do the same. What I mentioned, review all of the contract documents. Again, we'll regularly get a draft contract from a client for a large project. I'll say, hey, we need you to review this contract. There's no exhibits attached. There's a reference to specifications being part of it. Let's say it's a subcontract. And so the specifications are part of the contract. The design are part of the contract. And as I said, specifications often include legal terms, not just how you build it from a construction science terms. Those contract documents may also incorporate by reference the prime contract and impose all of the obligations the general contractor owes to the project owner on you as a subcontractor. So it's really important that you review all of the contract documents. Lastly, on this slide, trust but verify, to use the famous phrase or truncated phrase that Ronald Reagan used during the Cold War. With technological tools, there are efficiencies like compare docs features where you can easily redline two different versions of documents. Someone might create a red line for you saying, hey, here's the changes I made per your request. Be careful. Is the source creating the red line trustworthy? Do they actually know what they're doing from a technology perspective? Because we've seen lots of innocent mistakes. We've also seen sinister and deceptive red lines. Even, for example, the AIA or consensus docs, right? They have editing tools. So if you're working with a licensed product through their portals, it will, through their portals, track the changes that are being made. And the AIA, for example, will have a vertical line in the column signifying that there have been revisions to this section. And the AIA can even generate a changes document. We have seen contractors and unfortunately their counsel on lesser occasions, but we've still seen it, take that information from the AIA and then create a dummy document or erase the vertical line so it looks as though nothing has been changed. So you really have to be careful about that because of those risks. And remember too, what's your source? Who created the contract document, right? The AIAs, robust. They cover all kinds of details on a construction project. They're highly litigated, which means there's lots of interpretation, which is great because you know what the provisions actually mean. But they're heavily slanted to owners and architects unless they're modified. Consensus docs, more neutral, definitely not contractor favored, even though contractors as a group through trade groups created those templates, but they're not as detailed as AIA. And then of course, there's the ever prevalent private documents, which can range from mild to wild. So know your source and trust but verify. Okay, so let's talk about some clauses to look out for. So we're going to cover arbitration and litigation. Why? It's not that you want to be in a dispute, but you have to begin with the end in mind. To use a Stephen Covey phrase, famous leadership speaker, is if you get into a dispute, you have to have credible leverage or credible threats to negotiate your way out of the dispute so that you don't end up in litigation or arbitration. Well, the credibility of that threat can depend significantly on your remedies and the forum, arbitration or litigation. Indemnity is another big one. Obviously, that's a contractual risk shifting mechanism where you may be shifting risks that you have in whole or in part to others, or you may be assuming risks. So we're going to talk about that. Plans and site conditions, differing site conditions, deficiencies in the plans. I'm going to talk about the general rule of what happens when those things exist and how, again, there can be risk shifting mechanisms to look out for. Flow downs and ups, which are basically you are taking on responsibility. A flow down would be from a provision in a contract above you at a higher tier. Or a flow down is something that you may need to flow down or flow up to different tiers depending on what the obligations are. So there's phraseology we're going to discuss in some common flow provisions. Lien waivers are not all made alike. There's a statutory form. Actually, there's 4. We're not going to go over the forms specifically. We're going to talk about them generally and some things to look out for. Termination. Most people know that you can be terminated for screwing up, right? There may be what we call default termination provisions, but there's something called the termination for convenience, which may allow someone to terminate you, even if you haven't screwed up and you may be giving up certain rights, or you may need to have a similar provision to terminate people downstream. Pay if paid. This is another risk shifting mechanism on where you're shifting who may be responsible for payment or if you can receive payment at all. And lastly, we're going to cover sort of a bonus topic, which is price escalation provisions. All right, so let's talk about litigation versus arbitration. So very briefly, litigation is the supermajority of dispute resolution cases, sadly. Arbitration has been for many years very popular in the construction industry. We generally prefer arbitration over litigation for reasons that we're going to talk about in a moment, but it's not one size fits all. Litigation is the judge, jury. Arbitration is very different. So some things to contrast, right? In litigation, you have your free judge. Well, all tax-paying Americans know it's not really free, nothing is, but it's paid for by your taxes. There are court filing fees to file a complaint, to file a countersuit, and certain other things, but they're relatively small generally, and you're not paying the judge by the hour to do the judge's work. Arbitration, on the other hand, isn't paid for by tax dollars. It's paid for by the parties. And depending on the rules that are applicable, either there's going to be one arbitrator or a panel of 3. The panel would be only in extremely complex, high dollar cases. I would say generally think $10 million dollar disputes and up, though they can be panels for a little bit less than that. And the parties split the arbitrator costs. The winner is entitled to reimbursement of those costs. Litigation, your decision maker is what we call a generalist. It's a judge, supposedly some smart so-and-so lawyer who either ran through the political process for election to a judgeship or is appointed through a judicial nominating commission. There are good judges and bad judges, just like everything else, but a judge sees every kind of case there is, from construction to personal injury to auto accident to real estate and a million other things. And so the judges are experts at process, i.e., getting a case from beginning to end, albeit very slowly, but they are not experts in any particular area of law, nor are they experts in science like construction science and technique. Whereas the arbitrators are experts, okay? These are sometimes, again, depending on the dispute resolution clause. They may be former contractors. They, more often than not, they are construction lawyers like yours truly, who are construction experts. Some are board certified in construction law like me. Some are not. One of our firm members here has been a American Arbitration Association construction arbitrator for 30 years. And he's board certified in construction law. So you're getting subject matter experts. Litigation, boy, there's tons of due process, meaning you will have every opportunity for your day in court and your say. Translate that into extremely long and extremely expensive. Anyone who's been involved in litigation will tell you that unless your legal professionals have an extraordinary plan that they've put together at the beginning, which most do not, and they work at an extraordinary pace with a high level of urgency, your typical lawsuit, your litigation case is going to go 3 years. We've seen some go as long as 11 before ever going up on appeal. That's just trial process. The Florida Supreme Court says they're required to be done for a jury trial within, I think it's 18 months of lawsuit filing, and for a non-jury trial where the judge is the decision maker, within 14 months. That's still a long time in the life cycle of a business. And I will tell you that notwithstanding those rules that the Florida Supreme Court has issued, you need aggressive counsel that's going to push them to get them done that fast, because opposing counsel and the judge are going to be far more lackadaisical. Flip side, arbitration. Again, depending on the mechanism, these can be long, i.e. lots of due process, or they can be extremely accelerated. As an example, we've drafted for clients who wanted it, accelerated arbitration provisions where from beginning to end is 90 days. That's fast. But so there are ways you can customize it in your contract, but it can be much faster. Again, long process means high costs. In arbitration, the costs of your legal professionals can be controlled a lot more because things are streamlined. Even if it's not accelerated, things are streamlined considerably. Litigation is public record. Anybody can look it up. That can be a problem. It can stain your organization's reputation. Arbitration is completely private, the entire proceeding. The only thing that becomes public, if it's necessary, is the final judgment that the court signs and issues after the arbitrator has made a decision. Litigation, pros and cons. Pro is if the trial court gets it wrong, you have the right to challenge that on appeal. So you can go to a higher court, which is a 3-judge appellate panel. You don't get to retry the case. The appellate court takes all the facts that were in the record, all the evidence that was in the record in the trial court case, and applies the law. And if the law dictates a different outcome based on those facts, then you have a win. The downside to litigation appellate rights are it lengthens the time. The typical appeal process takes anywhere from about 12 months to 18 months because of court delays and the lengthy written briefing schedules. They are very expensive. And the appellate courts statistically about 30% of the time 30% of the time reverse the trial court, 70% of the time defer to their trial court judge colleagues. So your chances of winning are small, and worse, you invest likely 6 figures in your typical appeal. And at the end of that 12 to 18 months, the appellate court issues a decision that says, and I quote, per curiam affirmed, period, end quote. What the heck does that mean? It means the judge agrees with the trial court and isn't going to tell you why. And they have the right to do that. And as a business owner, I am, and as a lawyer, that would piss me off. And so it can be very frustrating to invest that time and money. Arbitration, the con and the pro is there's no appellate rights. So if the arbitrator gets it wrong, you're stuck. But that's why there's finality. That cuts both ways. There are very limited grounds to challenge an arbitrator's decision called an award. For example, if there are evident miscalculations, so there's a math miscalculation, or you can prove that the arbitrator was engaged in corruption, fraud, or misconduct. But noticeably absent from the list of reasons you can challenge an arbitrator's award is that the arbitrator just misapplied the law to the facts or misunderstood the facts. Pros and cons of arbitration litigation. Now, importantly, in the absence of a appropriately written arbitration mechanism in your contract, you have no right to arbitrate a dispute. You must litigate a dispute. So if you go, hey, arbitration sounds far more interesting than litigation because it can give us some tools, that's got to be drawn in your contract. And just like everything else, not all arbitration clauses are the same. You got to select the rules. You got to select the arbitration forum that's going to handle it. They're not all made alike. So that's an important thing to consider. And again, you want to talk about leverage and why this is a claims preservation mechanism. Imagine your adversary knows that your rights are only pursued in litigation, and that litigation could take 3 years. And let's say it's a payment dispute. They can drag out payment to you for 3 years. What's the likelihood you've got a lot of leverage to get that resolved early versus, let's say you've got an accelerated arbitration provision. You may not even have to aggressively pursue the arbitration. You've just got to point out the difference and that delay tactic isn't going to work, that it's going to be done and over with very, very quickly. And that gives you tremendous bargaining power to resolve matters. And if you can't, then legal counsel do what they do. And I can promise you this, most lawyers don't like arbitration because they don't like that there are no appeals. They don't like that they can't turn over every stone and look underneath it for a snake. But that's what gives you as business professionals the ability to resolve things quickly, is eliminating all of those things. So you've got a legal professional who understands arbitration. They're just gonna run right over the adversary because you can move it much faster. Okay, so let's look just a couple clauses. This is very simple, right? This is we'll call it a standard short form litigation provision. You don't have to select litigation. Again, that's the default. But here it says, we're going to resolve it in this location. Okay, 6th Judicial Circuit happens to be Pinellas and Pasco County here in Tampa Bay, but that's just a simplistic provision. Number 2, okay, this is a more elaborate provision, which is an arbitration provision. Okay, so what it says is a couple of things. One, before the parties can resort to litigation, i.e. the courts, we first want to try to get it settled. And how we're going to do that is the parties are going to submit to non-binding arbitration, right? So basically you have a very short, expedited mini trial that's cost effective. And the arbitrator says, well, hey, based on what I know, here's the winner, here's the loser. Well, you can make pretty good decisions at that point on whether you want to agree to settle or whether you want to pursue litigation. So that's just another flavor on dispute resolution. Okay, this one's far more complex. This one happens to be a pure arbitration clause. Okay, so what this does is a number of things. One, it says, okay, every dispute except for one, I'm going to set aside for a moment and we'll come back to that. Every dispute except for one type is going to be resolved via binding arbitration. The American Arbitration Association is going to oversee it and administer it, and they help select the arbitrators and the scheduling and all those kinds of things. We're going to select the construction industry specific arbitration rules, which are built around your industry. And we are going to select the subset of rules called fast track procedures, okay? Regardless of the amount in dispute, the contractor here is saying, I want this to be fast. I know I'm giving up some perfection, but I want to get this over with. And I know my lawyers are going to be prepared to go fast, and this is what I want. And then down in this area here, okay, options, right? We got, oh, by the way, we're modifying the fast track rules. So fast track rules, because it's fast, they cut out some things like a reasoned award. Reasoned award means the arbitrator's got to explain the numbers, right? So we're saying, okay, you're going to have or not have a reasoned award. And we can customize it further and say, you know, we want to customize some of the features. So in fast track, as an example, there are no depositions, meaning testimony under oath of a witness before the trial. But you can modify it in the arbitration clause, say, I don't want to give that up. I want to know what my adversary is going to say before they're on the witness stand officially saying it, so I can prepare a little more. I don't want to do trial by fire. Well, we can customize that kind of thing here. We have another provision starting here, okay? This is important. You don't want to be fighting in two locations. So let's say it's a defect claim. No, let's say it's a payment claim. You're a subcontractor and you bring an arbitration claim against the general contractor, and you've got a provision like this. General contractor defends and counterclaims is, no, I don't owe you money because your work was tardy, it delayed us, caused delay damages that we're eating from the project owner, or the work's deficient or defective. And so to combat that assertion, you need to point to anyone downstream of you, like subcontractors and material suppliers, and bring them to the table. But you don't want to have to do that in litigation and the other part of the dispute in arbitration, because now you're fighting in two locations. So this provision, contractor may join. The idea here is that you have the right to bring other parties into the arbitration proceeding, that it's not just between you and the other party to your contract. Importantly, to be able to do that, all of your contracts need to have similar dispute resolution mechanism. If your contract with the general contractor is a litigation dispute resolution mechanism, and your contract downstream with a sub is arbitration, you could be fighting in two forums. That's a problem. You don't want to do that. So what do we do? And again, this isn't perfect for every situation, but that we're arbitrating everything except one thing I said I'd come back to is addressed right here. So we're gonna arbitrate everything unless a different contract tells us otherwise. So in other words, if you're the, let's say this is a provision in the subcontract, and the general contractor says to the subcontractor, binding arbitration, but the prime contract between the GC and the owner is litigation. This provision saves your bacon, because it says if the dispute with the owner ends up in court, you don't have to be stuck with arbitrating against your subcontractor. You can go this optional route, but you can't draft it as either or. The language is legally hypercritical, because if this is too mushy and not specific enough, a court can find that you're not entitled to enforce it at all. Okay, so let's talk indemnity a little bit. What is it? As I mentioned, it's a risk transfer mechanism where someone's assuming responsibility to another. Now, this is so frequently done in construction that it's worth talking about today, because it ranges wildly. Again, these are not boilerplate. You might see an indemnity heading or you might not, but the word indemnity or indemnify or hold harmless, those are red flags, or at least caution flags. Those are the words, the types of words that are needed. So as an example, you can shift responsibility completely. So I can draft a provision that says in a general, so let's say I represent a general contractor and I'm writing a subcontract. I have a provision that says the subcontractor shall indemnify and hold harmless general contractor, project owner, project architect, or whoever else I want to name from, and then I have a laundry list of things that you're protecting all those people from. And then I say whether the harm is caused in whole or in part by the subcontractor. What does that mean? It means as a subcontractor, you could be paying attorney's fees or damages or losses that you didn't even cost, that someone else cost. Is that enforceable? Yep, sure can be. So that is covered in what we call an anti-indemnity statute. I'm going to explain that more in a moment, but this is an example of an indemnity clause. They can be a sentence, or more likely they're much longer than this, but you can see it's a huge laundry list. So, we've got subcontractor holding harmless all these people, right, for any kinds of claims, including attorney's fees, arising out of the project, right, whether or not caused in whole or in part, sorry for my highlighting, by the active or passive negligence of someone indemnified. Why do we do that? Well, because if an indemnification is asserted, you don't want this finger pointing two different directions. Well, they're at fault. No, they're at fault. And then you're in this long battle litigation to sort out who's at fault and how much their percentage of fault is. So that's why these kinds of provisions exist. They are commonplace. They're very dangerous. The anti-indemnity statute in Florida statute in 72506 is applicable specifically to construction projects. And what it says is we don't like these indemnifications where someone is indemnifying someone else from that someone else's own fault, their own bad conduct. We're not going to enforce that unless you comply with this anti-indemnity statute. And what it requires is that the indemnification provision have a monetary limit on the amount of that very unique indemnity provision. And that amount has to bear what's called a reasonable relation to the contract. So for example, it might be, words that like the limit of this indemnity shall be 1.5 times the price of the contract, or shall be $1 million, or whatever has a reasonable relation. That limitation is only applicable because of this language, whether caused in whole or in part by the active or passive negligence of the party that's receiving the benefit of that indemnification. So indemnities are really important. And by the way, and we're going to cover this in a little bit, you may be able to procure insurance to cover some of your indemnity obligation. Construction is a risky business. And so the key is risk mitigation through mechanisms that are available to you, not avoidance of the risk, because if you try to avoid all risk, you will be bankrupt as a contractor. But in your general liability policy, you will find a term called insured contracts. And it's defined in several different ways depending on the policy form. And some policies cover insured contracts, some don't. You can often buy endorsements to cover insured contracts. But basically what insured contracts means in these policies is you are assuming an obligation that you would not otherwise have. In other words, you're the subcontractor, you did nothing wrong, but there was a job site injury and you're going to agree to cover those costs, right? That could be protected through insurance if you're required to provide one of these things. And if you're forcing someone to provide this kind of indemnity, you may want to specify in your contract that that subcontractor has insurance to back up the indemnity in case the subcontractor becomes insolvent or goes bankrupt. Okay, so let's talk a little bit about plans and site conditions. So we have something called the Spearin Doctrine. Okay, the Spearin Doctrine came from a U.S. Supreme Court case many years ago, and basically what it says is that if the contract requires the contractor, whether general contractor or subcontractor, to build in accordance with plans and specifications provided by the project owner, right, through architect or otherwise, then the contractor or subcontractor is not responsible for building something that's defective, as long as the work itself wasn't defective, as long as you comply with plans. Well, that makes sense. That's fair. You didn't create the plans. Now, if it's a design build, different story. The contractor who hires the design professional has responsibilities. Side note, make sure you have appropriate insurance as a contractor if you are engaged in design build activities. Your general liability policy typically excludes coverage for design issues, so you may need endorsements or to buy a separate policy to cover those if you're taking on design build. In any event, the Spearin Doctrine can be eliminated. That risk can be shifted through contract language, where even though the owner or the owner's architect are providing the plans, the contractor is not only responsible for building per plans, but takes ownership of the plans, such that if there's a problem in the plans, the owner and architect aren't responsible, the contractor is. Now, there's some technical language that needs to be used to do that. But so here's some examples of what that risk shifting would look like, okay? So contractor assuming the obligation to verify accuracy and completeness, notifying owner of errors and omissions. And importantly, the last sentence is key, assuming responsibility for those errors and omissions if the contractor does not bring them to the owner's attention. Now, there are provisions that can be really nasty where it's, you know, within so many days, et cetera, et cetera. But this is a risk shifting mechanism. This would shift liability from the owner or architect to the contractor. This comes out of a municipal specification package, and this one's more limited concerning subsurface conditions. Okay, but again, risk shifting mechanism. The third one, I mentioned the A201, general conditions of the contract from the AIA series of documents. It has this particular risk shifting mechanism. And when I said they're owner architect favored, well, here's just one example, right? So contractors got to carefully study. Well, yeah, we know. Of course, you're going to do that. Take field measurements, observe conditions affecting the work, promptly report errors and omissions. And in other sections of the A201, it says that the contractor is liable for costs and damages that are suffered by the owner if you fail to do these things. And that's buried in a completely different section of the A201, not this risk shifting section. You will never see the word Spearin. So you have to look for language like this. Site conditions, okay? What I'm talking about here is differing site conditions. Generally, the owner is responsible for site conditions which differ from those that are readily observable on inspection or which are described in the contract documents. We litigated a case and settled it very favorably to our prime contractor client last year, where the property on excavation had 3 boulders in it, each of which were larger than a pickup truck in Florida. Very, very unusual. And the fight was over the cost and responsibility for the massive increased costs and equipment to deal with those rocks. Again, the responsibility, however, can be shifted. So here's an example of one where it's shifted from owner to contractor. Again, our famous A201. Obviously, I'm not going to read it here. It's on the screen, but basically this deals with subsurface or concealed conditions that differ materially, unknown physical conditions. And here, contractors representing by signing the contract. I've visited the site. I've not only visited the site and read all the contract documents, but I've familiarized myself with local conditions in the geography. So even if I can't see it, if I know that there are conditions like this in the general vicinity, then I'm on notice that there could be here. And notice there's a 14-day reporting mechanism. So some really tough provisions. This is from a private contract, one that we had drafted, but again, another example of risk shifting, where the subcontractor here is making warranties and representations to the general contractor that, it's visited, familiarized itself, fully understands the facility's difficulties of executing the work. And here it's even worse than the 14 days after discovering an event, prior to beginning work. There's all sorts of requirements. And then this one goes on subcontractors not entitled to an adjustment of price or an extension of time. So risk shifting. Flow ups and flow downs, okay? We're gonna go through this kind of quickly because there's all different types, but the point is incorporation by reference is what we're talking about. This goes to what I mentioned earlier. Make sure you're reading all of the documents, all of the contract documents. Some of the problems with these are, again, they're designed for clarity, right? To bring clarity, but no one's perfect. And especially if legal professionals with construction expertise aren't involved in drafting each and every portion, you're going to have conflict. So order of precedence, priority. In the event of a conflict between documents and the language in the documents, what provision controls? Believe it or not, there are disputes over that, and that's easy to resolve through an order of precedence or priority provision. Obviously, we talked about indemnification, right? If you're the general contractor and your project contract with the owner requires you to indemnify the owner for certain things, you better flow down a comparable indemnification obligation to your subcontractors. Same thing with insurance, right? Payment rights and dispute resolution joiner, we already talked about. Even submittals, requests for information. Again, if you have a upstream obligation to provide, to deliver an RFI or a submittal within certain days of discovering an event or by a certain date, and you're relying on your subcontractors, you need to flow those obligations downstream and make sure that your subcontract gives you enough time to get what you need from your sub to timely flow it upstream. So this is what I talk about flow ups, flow downs, is you got to look at the timelines and make sure they align, and make sure that really critical provisions that you're bound by get flowed downstream in your subcontracts or subcontracts. So what do some of these things look like? This is a flow provision, right? So subcontractors bound to the contractor. So this is something that's a flow down. GC's flowing down to the sub by all the terms of the contract documents. The contract documents in this particular contract include not only the subcontract, but the prime contract, the plans and specifications, and a whole bunch of other things. And that the sub is assuming the same duties to the general contractor as the general contractor assumes to the owner. This is a classic flow down provision. Ought to get your attention and say, I need to look at these other documents that I don't have. Here's a very simple flow down: incorporation by reference, or hereby incorporated. Again, that's making all the terms of a contract you may not have seen and pasting them into your document by this mere reference. You sure better know what those are. Again, longer. This particular provision comes from a private contract we created for a national multifamily affordable housing developer. And as you can see, we're incorporating all kinds of things, standards imposed by the FHFC, which, by the way, those are ad hoc. There are written standards, but it's basically whatever FHFC says for the project ad hoc. So this was a general contractor's contract flowing it downstream. So there's all kinds of specific things. You want to be on the lookout for these kinds of provisions that reference prime contract, contract documents, other laws, rules, agencies, etc. Get another one. This happens to be a payment condition. So basically what this is saying is any payment conditions or conditions to payment imposed in the prime contract, we're incorporating those by reference downstream, and all lower tier subs, suppliers, etc., become bound by that. So it's really important to know what those are and make sure you can comply. And this is just a flow down of an indemnity obligation, a very simplistic one. But again, you can see when you're a subcontractor and it's referencing the prime contract, it's referencing a project owner, a design professional, those are flow provisions that you need to wrap your head around. Lien waivers, as I said, statutory forms, right? There's four. There's a progress and final, and for both progress and final, there's conditional and unconditional. Unconditional means you give it, and whether you get paid or not, you're stuck. You've given up your lien right. You can't cry fraud or the check bounced or anything else. Conditional means it's only effective once you've received the money in good and valid funds. The lien law says that non-statutory forms are enforceable. I mean, you could literally go up to 713-24 statutes and copy paste, and there's your waiver form. You don't need to be a lawyer or legal professional to do that. But non-statutory forms, meaning custom forms, are enforceable if signed and to the extent signed. However, unless the contract that you sign requires you to sign a particular form, then you have the right to object to some custom form and say, I'm only going to sign the statutory form. We've dealt with really nasty persnickety custom forms where, for example, not only are you giving up a lien right or a right to claim against a payment bond, you're also giving up contract claims, you're giving interim affidavit as to construction and warranties, so they are not all made alike. So no, again, if you have a contract that's got an exhibit with a lien waiver form or a bond waiver form, look at it. Make sure that you're willing to sign it, and make sure that if you're obligated to sign it, chances are you have to make sure everyone downstream signs the same thing. And unless you have a contract provision, a flow down that requires them to, you're going to be in trouble. Okay, so this is statutory. I'm going to skip that. This is non-statutory. And what I want to point out here as an example, whether billed or unbilled, and assert any contract claims, right? So they can be nasty, and there are those that are far nastier. Termination for convenience and breach. So material breach is somebody's really screwed up. You have the right to fire them, and there's all sorts of rules about that. This is a typical material breach provision where it's listing certain bad deeds that if you do these, you can be terminated. If there's no termination provision at all, then it's a default termination provision. It's got to be a material breach, meaning significant, not some trivial violation. You got to look out for convenience terminations. They are purely a creature of contract, meaning no law imposes them. And it's literally what it sounds like. I don't like that the sky is moderately gray today, so I'm terminating my subcontract with you. Now, I'm not going to do it for that reason, obviously, but I might have some other reason, like you haven't been doing a great job, but I'm not sure you've materially breached, right? So it's kind of a safety net. And the point is, the rules are different. So the convenience termination provision specifies how the termination happens and what the parties are obligated to do or entitled to receive in compensation when there's a convenience termination. So I'm going to show a couple of examples. Okay, this is in a prime contract. The owner can terminate the owner's convenience and without cause. All right, so what happens? Cease operations. Protect and preserve the work. Terminate all subcontracts. Right? So if you're a general contractor that signed this and you're obligated under this provision to terminate all the subcontracts downstream, your subs are going to be upset. They go, I want my lost profits on this job. And they will have a right to sue the general contractor for those lost profits, unless the general contractor flows down an appropriate termination for convenience provision that allows the general contractor, when it's terminated for convenience, to also terminate the sub for convenience. And here's what it says: owner pays for properly executed work, and some basic costs incurred and directly attributable to the termination. But it could say anything. It could say you get paid for demobilization. It could say you get paid nothing but for work in place. Goodbye. So you got to look out for these provisions. They're really handy to have when they're beneficial to you, but you got to make sure you flow them down. This one is similar concept, but I want to show you this. Okay, this is really neat. So your legal professional would love a provision like this if you've got a termination provision that you want to use. So the rules are different, as I said. Let's say you're a general contractor and your subcontractor's not been performing well. If your subcontractor has materially defaulted, you terminate the contract, it means you don't have to pay the subcontractor any further, particularly if your damages exceed the amounts due. You're completely relieved of that obligation. But if you say default termination, and later a judge, jury, or arbitrator finds that the sub wasn't in default, then the general contractor actually will be found to have improperly terminated, and you're responsible to pay the subcontractor's lost profits. Well, this saves your bacon because it allows you to terminate for default. And then it says, if someone later determines the subcontractor wasn't in default, then the termination will be magically transformed into a termination for convenience, which means you, the terminating party, don't have to pay lost profits. Is this enforceable? Yes, if it's appropriately written. Pay if paid. Be careful. Pay if paid and pay when paid are different. So I'm going to start with the second bullet point. All right. Pay when paid is a timing thing, like within a reasonable time, within 10 days, within 5 days. It's a time frame. That is actually not enforceable. A pay if paid provision prevents, for example, a subcontractor from getting paid on a project by the general contractor if the general contractor isn't paid for that subcontractor's scope of work. That's the first bullet as an example of one. Again, there is magical language. This is a summary of some of that magical language, but it's really important if, again, prime contract, like if you're the general contractor and you've inserted a pay if paid in your subcontract downstream and you're a subcontractor, you better make sure you have a pay if paid clause in your subcontract or a flow down provision that incorporates by reference, or you could be in deep trouble where you're not obligated, you're not allowed to be paid, yet you have an obligation to pay your sub. Okay, price escalation, because this is top of mind. So many contracts have what's called a force majeure provision, which means act of God. What the industry as a whole learned, particularly legal professionals, is if there was ever something that really was boilerplate, sadly, force majeure was treated as it. It was the hurricane, the tornado, the volcano, those kinds of things. And no one ever considered 2020 happening. And whichever side of the debate you're on, the courts were all over the map on whether it was an act of God, whether it wasn't, does it trigger the force majeure? So force majeure can relieve you of obligations to perform. It can grant you title extensions. It can give you additional compensation. So this is kind of a neat clause to have, but be aware of, because if you've got, again, you're a GC and your sub has a force majeure, this might come up and bite you in some future year if something happens. The AIA has equitable adjustment language, which is basically a fairness provision that says, hey, if there's a change condition or a change directive given by the owner, or there's some other thing that we can't agree on, or some craziness has happened, like supply chain issues, something no one expected, the architect can make a recommendation to equitably adjust the contract, either time or price or both. And under certain instances, the owner can be bound to abide by that. On others, the owner has a right to contest. So there's lots of different ways to deal with those. Frustration of purpose, right? That is literally, I can't even perform. Like, you specified this particular pipe and it doesn't exist, at least in the current supply chain. That can give you grounds for time extensions. It can give you grounds for price increases, even if those aren't consented to. For sake of time, I'm not going to spend a ton on these. Again, I can circulate, or Carrie can circulate this as a PDF to everybody, but this is an escalation provision as an example, where a baseline price is defined, a procurement price, uncontrollable increase, and then the delta is, you're entitled to the delta as an additional change order. It's sort of mechanically forced. There's all kinds of ways to do this, including, only if the increase is, 20% or more, or 10%, lots of different flavors. Okay, so additional claim preservation issues. We want to look both at contractual and statutory, right? So we want to look for words in your contract, right? So these words, before, condition preceding, after, et cetera, deliverables, submittals, notice, shall not, may not, permission, consent. These ought to be key words to key in on, because these are potentially problematic issues that you need to wrap your head around, and you may need to flow down or up. Statutory, right? Some of the timelines for payment, right? If it's a lienable project, so it's a private project, whether it's bonded or not bonded, privately owned project, you've either got to serve a notice to owner or notice to contractor, or both. Because on a privately bonded project, you might have both the right to make a claim against the payment bond and the right to lien. So it's 45 days from first furnishing, which is not necessarily your first day on the project. If you are specially fabricating materials, it can start earlier. So when you sign the contract, if you're a sub or material supplier, serve your notice. Liens and notices of non-payment for bond claims, 90 days from final furnishing, and so on. So there's timelines to be aware of. Also look for these, right? So you've recorded your lien, or you've served a notice of non-payment on a surety. Look out for a notice of contest of lien or notice of non-payment. That shortens your deadline to file an action to foreclose the lien or an action against the surety from 1 year to 60 days. And if you miss the 60, you're done. There's no extending that time period. Also look out for a request for sworn statement of account. Even if you've provided a final affidavit, or you're sending demands through lawyers, or you've already emailed them a summary of your account, you must respond to this within 30 days or your lien and bond rights go away. Miller Act, federal projects only, but basically the short version, federal projects over $100,000, there's a bond. First tier subs and materialmen are protected under certain circumstances. Second tier subs and materialmen can also be protected by the prime contractor's bond. First tier don't have to send any kind of notice before filing suit. Second tier must provide notice within 90 days of their final furnishing of a claim, or they do not have the right to file an action against the bond. So in summary, Contract compliance best practices. Oh, excuse me. I got one more slide. We're almost done. Create an abstract. So, you ought to summarize key provisions so you can easily reference them once you're on the project. Train your team on how to do that. Extract provisions, put them in the project file digitally or otherwise. Create templates in advance of needing them. If you've got a 24 or a 48-hour contractual deadline, and there are lots of those persnickety deadlines in contract documents, you don't want to be fumbling around, A, looking for the provision, and B, having to create a form because you'll blow the deadline and you may have lost your claim. Teach your team about what I call notification triggers. So if certain things are happening on the job that are relevant to contract provisions, like concealed condition, like a directive that's received, like a safety infraction, whatever they are, the triggers, they know what to do in advance for those. Lay those out in advance. Businesses have their own general ones, but you might need to supplement those to be project specific. Documentation is everything. So make sure when your team is particularly using cell phones for text messages, and you're having challenges on a project and you anticipate future claims, make sure your employees are preserving those text messages and they don't get wiped. Also be careful on documentation. A lot of times the notice provisions are really persnickety. For example, we've drafted one where it says, okay, you've got to serve this notice, you got to do it within 48 hours. It's got to go to this address via return receipt requested. And it's got to be attention CEO or attention John Smith. So it's, and we'll get notices. They'll come in via email, text message, phone call, non-certified, or they'll hit all the boxes, but it wasn't to the attention of the CEO and you failed to comply. So be careful that you study your notice provisions. So these are kind of the takeaways. Again, read everything, look out for the 7, make sure you're careful about flow down provisions, talk to your insurance agent, show your insurance agent, not just the insurance provisions, but the entire contract, because they'll look at indemnities and other provisions and talk to you about your insurance coverage. Narrow the indemnity obligation when you can, watch for waiver forms. Be careful about convenience termination and flowing that down, and pay if paid clauses, and so forth. And make sure you're training your team. If we have a few more minutes for anyone who'd like to stay on, Carrie, I'd like to open it up to questions.
Wow, that was a lot of information, all good. I took like 4 pages of notes myself. Anybody have any questions? Anything come to mind that he talked about that you want to ask him while we have him available?
No, hearing none. Does, if anyone who would like a copy of the PowerPoint from today, I'm going to post my email address in the chat.
Okay, yes, Pablo already asked for it, so that'd be great.
Feel free to do that, Carrie. I'll get you a copy of it, and certainly we have a periodic digital newsletter that we circulate. It's usually about once a quarter. And it's not marketing in nature. It contains purely legal education. So it'd be a short article on contract review or construction defects or lien law, or one of our most recent is a legislative update on the laws. So if we have your email addresses,
Pablo, please mute your phone. Sorry.
So, well, I appreciate everybody's
I'm
time
trying.
and attention, and unless anyone has any other questions, I'll sign off and wish you all a good day.
Well, thank you so much, Justin. It was very informative. Really appreciate. Hopefully, maybe we can repeat this in the future when we know we've got more participants. So thank you so much.
But
Thank you.
Good job.
Thank you.
Okay, any other more in the chat?
I got some. Come on, give me. You got the last one? Hold on.